Imagine you take over a McDonald's franchise, but half of your managers are die-hard Burger King executives. They don't like your menu and actively sabotage your operation, pushing Whoppers instead of Big Macs, and undermining your plans at every turn. Sounds absurd, right? Yet in Washington, D.C., presidents often face a similar dilemma with independent agencies. When President Trump returned to power, he found key federal boards led by people fundamentally opposed to his agenda, the equivalent of having a general lead an army that has lieutenants allied with Russia and sergeants loyal to North Korea. So what did he do?
You're fired.
And that sparked a legal firestorm over whether a president can sack the heads of independent agencies at will. This is a look into the constitutional dynamics that happen when Trump says,
"You're fired. You're fired. You're fired."
In early 2025, Trump made headlines by ousting 2 officials in worker-related agencies. He removed Jennifer Abruzzo, the National Labor Relations Board General Counsel, a Biden appointee who had aggressively expanded workers' rights, and even Gwen Wilcox, a Democratic member of the NLRB's board. This unprecedented move left the Labor Board short of a quorum, effectively paralyzing its ability to issue decisions. On top of that, Trump also fired Kathy Harris, a Biden-nominated member of the Merit Systems Protection Board, the panel that hears federal employee appeals. Harris's removal threatened to grind the Merit Board to a halt as well, since without her, the board lacked enough members to decide cases. These officials weren't just random bureaucrats. They had actively pursued policies contrary to Trump's platform. In fact, their backgrounds and actions made their dismissals more understandable from Trump's perspective. Jennifer Abruzzo, a Biden-era official and former union lawyer, used the NLRB to expand workers' rights. For example, she won a ruling outlawing mandatory captive audience meetings, where employers tried to dissuade unionizing. Her aggressive pro-union approach infuriated many businesses, including giants like Amazon and SpaceX that sued the NLRB for overreach. To a pro-business president, Abruzzo was an ideological adversary, using her office to push a radically pro-union agenda. Gwen Wilcox was another union-side attorney by her background, and she took a broad view of labor protections, reliably siding with unions on key decisions. In Trump's eyes, keeping Wilcox on the board would be like keeping a rival team captain in your own dugout. Kathy Harris, who was on the Merit Board, moved to reinstate thousands of federal employees whom the Trump administration had fired or furloughed. Essentially, she was blocking Trump's efforts to discipline or remove what he viewed as a stubborn bureaucracy. Notably, Harris was appointed to a term lasting until 2028 and by law could only be removed for inefficiency, neglect of duty, or malfeasance, a protection Trump chose to ignore, arguing these restrictions shouldn't bind him. Unsurprisingly, these fired officials cried foul. Wilcox declared her removal illegal, vowing to fight it in court as a violation of long-standing Supreme Court precedent. Harris sued as well, since statutes purportedly shield her position. This sets the stage for a constitutional showdown. Can the president really say,
"You're fired,"
to independent agency heads who oppose his policies? Trump's team argues yes, pointing to the Constitution and recent Supreme Court decisions. His opponents argue no, citing a New Deal-era precedent that protects independent agencies. Let's unpack the clash. At its core, the debate is about the president's Article II authority. The Constitution tasks the president with taking care that the laws be faithfully executed, which implies he must oversee and control executive branch officials. After all, how can a president carry out the laws if his top aides or agency chiefs actively defy him? Early on, the Supreme Court recognized this necessity. In Myers v. United States from 1926, the court held that the president has the exclusive power to remove executive branch officers he appoints. Chief Justice and former President William Howard Taft reasoned that without removal power, the president couldn't be truly responsible for the executive branch's work. The court noted a president must be able to remove those for whom he cannot continue to be responsible in order to ensure faithful execution of the laws. However, a famous 1935 case introduced an exception. In Humphrey's Executor v. United States, The Supreme Court upheld Congress's ability to give certain officials job security by restricting the president's removal power. That case involved a member of the Federal Trade Commission, a part of a multi-member independent commission. The court said that if an agency performs quasi-legislative or quasi-judicial functions, not purely executive tasks, Congress could require that the president only fire its leaders for cause. That's for misconduct or incompetence. Humphrey's executor thus created the modern independent agency, bodies like the FTC, and by extension, the National Labor Relations Board or the Merit Board, whose leaders have fixed terms and some legal protection from at-will firing. This precedent became the main legal shield for officials like Abruzzo, Wilcox, and Harris. It's why they argue Trump's purge is unlawful. Under Humphrey's executor, presidents since 1935 generally haven't been allowed to oust independent agency heads just over policy disagreements. Humphrey's executor can be viewed as excessively progressive by prioritizing a sort of technocratic, expert-led administration over direct executive oversight. By shielding FTC commissioners from presidential removal, the court empowered Congress to create independent agencies insulated from political influence, potentially undermining the president's ability to shape policy. That's potentially problematic for the rule of law and separation of powers. At least one famous Supreme Court justice, Justice Scalia, noted that in his dissent in Morrison v. Olson, who said it was a product of an activist anti-New Deal court bent on reducing the power of President Franklin Roosevelt and should deserve another look as to its legitimacy. Those who favor Humphrey's executor argue it insulates so-called apolitical boards from partisan politics. They claim this allows independent experts to tackle complex decisions objectively and fairly. But honestly, the idea that anyone sitting on a governance board in Washington, D.C. can be genuinely apolitical seems naive at best, disingenuous at worst. Take Abruzzo from the NLRB, whom I mentioned earlier. She pushed positions asserting that worker activism on highly charged social issues, like Palestine protests, was somehow protected activity because of a vague workplace connection. She didn't stop there. Abruzzo repeatedly advanced novel legal theories and aggressively advocated expansive remedies for workers, positions far outside traditional legal boundaries. Similarly, Wilcox also championed bold, labor-friendly positions that significantly burden small businesses. There's plenty of other examples in history, too, about these so-called neutral, apolitical experts. There's Mary Frances Berry. She was the chair of the U.S. Commission on Civil Rights from 1993 to 2004. She was a Democratic appointed nominee in 1980, and she became known for defying oversight and taking unilateral actions on the Civil Rights Commission. She refused to seat a lawfully appointed Republican commissioner in 2001, vowing it would take federal marshals to make her comply, and even convened meetings without informing newly appointed members. Berry was accused of sidelining dissenters, for example, withholding meeting details from GOP colleagues and denying their staff equal resources. Her combative leadership led the Wall Street Journal to dub her agency a national embarrassment, illustrating how difficult it was for presidents, Reagan through Bush, to rein in a stubborn, independent official. Berry's tenure sparked legal battles, and Reagan's attempt to remove her was rebuffed by courts and highlighted the difficulties with removing independent agency heads. Viewed in this light, forcing presidents popularly elected by the people to have to deal with the tantrums and stubbornness of independent agency heads seems like a bad way to run the government. What bothers me more deeply here is that these experts really don't offer neutral expert opinions. They're frequently, unquestionably, political. Some administrations prioritize small businesses. Others favor organized labor. Pretending these boards are staffed by impartial technocrats is like claiming Supreme Court justices are selected purely for their legal skill, or politicians run campaigns solely to serve the public good. Comforting perhaps, but hardly believable. It's time we acknowledge the truth. These boards aren't apolitical. They're deeply political institutions dressed up in the comforting disguise of neutrality. Fast forward to the 21st century, and the Supreme Court has started tilting back toward executive control. Several recent decisions have chipped away at the scope of Humphrey's executor, reinforcing the president's removal power. Free Enterprise Fund versus PCAOB in 2010, this case targeted the Public Company Accounting Oversight Board, a regulatory board insulated by 2 layers of removal protection. The members could only be fired for cause by SEC commissioners, and those commissioners in turn could only be fired for cause by the president. The court struck down this double for cause structure as unconstitutional. Why? Because such double insulation completely strips the president's removal power, leaving him no meaningful control over officials who wield executive authority. In other words, the president cannot ensure that laws are faithfully executed if multiple barriers prevent him from removing subordinates who misbehave or defy his policies. This ruling invalidated one extreme of agency independence, affirming that at least one layer of accountability to the president is required. In 2020, we get to Sealah Law versus the CFPB. The court took on the Consumer Financial Protection Bureau, an agency led by a single powerful director whom the law said the president could only fire for cause. In a 5-4 decision, the court ruled that these for-cause removal restrictions on a sole director violated the Constitution. Chief Justice John Roberts underscored that the president's removal power is the rule, not the exception. The majority reasoned that, unlike a multi-member commission, a single director wields significant executive power alone. Allowing that person to be unaccountable to the president undermines democratic control. The outcome, the director, can now be fired by the president at will, aligning the agency with Article 2's vision of a unitary executive. Notably, even as the court upheld narrow exceptions like Humphrey's for multi-member boards, it's repeatedly emphasized the primacy of presidential control. As Chief Justice Roberts explained in Sealah Law, the Constitution's design is to make the executive branch accountable to the people through the president. Thus, the executive power belongs to the president, and that power generally includes the ability to supervise and remove the agents who wield executive power in his stead. In another case, the court put it more bluntly. The president cannot take care that laws be faithfully executed if he cannot oversee the faithfulness of the officers who execute them. These principles suggest that the president must have final say over personnel who exercise executive authority. Otherwise, you end up with unaccountable bureaucrats, or as some call it, a fourth branch of government, operating beyond the control of the elected chief executive. And let's return to our fast food analogy. If you were that McDonald's owner, would you tolerate Burger King loyalists in your kitchen if they were actively undermining your recipes? If you were a new pope, would you accept Lutherans running your church? Of course not. You'd replace them with people who support your vision. Similarly, a president is elected to implement certain policies after the people have spoken, whether they're pro-business or pro-labor or anything in between. Keeping ideological opponents in charge of key agencies is a recipe for sabotage. In President Trump's case, the NLRB and MSPB officials he fired were pursuing agendas antithetical to his. Expecting him or any president to leave these leaders in place would be as nonsensical as asking Coca-Cola's CEO to keep Pepsi's vice presidents on board. It's simply not how executive leadership works. The framers of our Constitution chose to vest the executive power in a single president for a reason: to ensure energy, unity, and accountability in government. Voters know who to credit or blame for the State of the Union, but that accountability breaks down if the president's hands are tied, if he's forced to allow holdovers or appointees from a rival ideology to thwart the agenda the public voted for. Proponents of strong removal power, including Trump's supporters, argue that without the ability to fire, a president becomes a mere figurehead, hostage to bureaucrats or commissioners who might pursue their own interest or the prior administration's policies. To be fair, defenders of independent agencies worry that allowing presidents to fire Agency heads at will could politicize enforcement or undermine the checks and balances necessary to our system. They often invoke Humphrey's executor to say, hey, some agencies are meant to be neutral experts above the political fray. But the counterargument is that, in reality, no agency is truly neutral. And when disagreements boil down to policy, the democratically appointed elected president's vision should prevail. Without this, independent agencies can become independent in a bad way, independent of democracy, insulated from the will of the people. In the ongoing legal battle over Trump's firings, the courts will ultimately decide how far presidential removal power extends. The Supreme Court's conservative majority seems inclined to expand executive control, potentially even revisiting that 90-year-old Humphrey's executor precedent. The stakes are high. It's not just about Trump or any one president, but about the fundamental question of who controls the administrative state, something that's terribly important. Is the elected president or a cadre of unelected officials with their own agendas in charge? From the perspective favoring executive control and Trump's position, the answer is clear. The president must have the ability to fire the heads of executive agencies, even independent ones, especially when those officials are working at cross purposes to his mandate. It's about ensuring that we, the people, through our chosen president, steer the direction of policy. After all, Americans don't vote for the National Labor Relations Board General Counsel or for merit board members. They vote for a president to run the executive branch. And if that president can't say,
You're fired.
to an insubordinate agency chief, it undermines the very principle of accountable government. In the end, whether it's running a fast food chain or the federal bureaucracy, someone has to be the boss. And the Constitution says that the boss is the President of the United States. Thanks for joining today. Each week we tackle one current constitutional controversy and another evergreen item of constitutional law. My goal is to equip you with the tools necessary to solve these puzzles yourself. Please be sure to like and subscribe and join us next episode as we jump into the mysterious heckler's veto in First Amendment case law and explain what it means for you.